Good evening to you all. My name is Christoph Paulussen and I'm a senior researcher in international humanitarian law and international criminal law here at the Asser Institute. I wish to welcome everybody to the very first Supranational Criminal Law Lecture of the year 2015. The Supranational Criminal Law Lecture Series, or SCL Lecture Series, is a lecture series on international criminal law and has been organized since 2003 by the Asser Institute in cooperation with the Coalition for the ICC and the Grotius Center for International Legal Studies of Leiden University. Tonight's speaker is Mrs. Harriet Ssali Lule, and she's the Deputy Registrar of the ICD, which is not the Asser Institute's International Crimes Database, to which we upload videos of this lecture series, but that other ICD, the International Crimes Division in Uganda, and she's currently on a visiting professionals program at the ICTY. She has an LLB from Makerere University in Uganda and an MBA from Birmingham City University in the UK. She has experience as a lecturer of laws and interests are voluntary work with Rotary International, and last but not least, she's married with 3 children. Mrs. Ssali Lule will speak about the ICD, so the first domestic international crimes court set up in Africa, mainly to try perpetrators of the Lord's Resistance Army, the LRA war led by Joseph Kony. And I think the timing of our lecture could not have been better in view of Dominic Ongwen's arrival at the ICC last night. So, Mrs. Ssali Lule, many thanks for coming, and you have the floor.
Thank you. I think I'll stand because I'm so short. Just so everyone has a good view of me. Is this on? Hello. Good evening. As Christoph has already said, my name is Harriet. I came to The Hague some 3 months ago as a visiting professional at the ICTY and was very interested in seeing how an international criminal tribunal is run, because obviously I'm the Deputy Registrar of the International Crimes Division. So I had this idea, come to The Hague, just 3 months, and then I'll go back home. And I've had the pleasure of meeting so many people interested in the international criminal justice system that it's just been amazing. However, I have really found that there's a great divide between reality on the ground and what's being taught at university and at institutes. When I look at Uganda, my country, anyone been to Africa? Great. Wow. Uganda? Great. Wow. I have fellow Ugandans here. The question is always, why is it taking so long? Why all the technicalities? Why are people always talking about complementarity and the failure of national jurisdictions? Why does all that matter? What should matter is that they're victims. People were killed. There was a war. And people want justice. But, we get all these questions about, domesticizing the Rome Statute, ICC Act, and all these things that people just do not understand. So now, look at what's happening. We've got 2 courts who can try the same kind of war crimes from the same country. Interesting, amazing. And, it's all these questions about amnesty. When amnesty was introduced in Uganda, it was to stop the war. People were tired of dying. Children were being abducted. Joseph Kony was not getting arrested. U.S. forces looking for him. Nothing happening. So the government said, yeah, amnesty should do the trick. And it did do the trick. But is peace justice? Or does justice create peace? That's the million-dollar question. If you look at the victims of the war, the LRA war has been very unique in that it has created 2 different types of victims. You've got the victims of the war, people who have been killed, raped, abused, the normal type of victims. Then you've got the victims, the soldiers themselves who were abducted, girls and boys, young, some as young as 8 years old, who were abducted and forced to become soldiers. So how do you balance that? How do you handle that? I can't forget an article I read recently about Dominic Ongwen's wife. She ran away. She managed to escape in 2005 or 2006. She's called Florence Ayot. And when she heard of her husband, war husband's capture, she said, "Oh, but he's a good man. He was abducted when he was 10 years old." I was abducted when I was 9 years old. And I thought to myself, and I'm like, this is so wrong. A wife who was 9 and a soldier who was 10. I mean, I wondered if I was with her in the same room, I'd want to shake her and say, wake up, you know. This is just so wrong. You cannot think that is right. But unfortunately, that was her reality for 15, 20 years until she managed to escape. So when I'm speaking about the International Crimes Division today, I want us to have that in the back of our minds, that we do have victims, we do have witnesses, and they're trying to understand why is it that the prosecution is getting so complicated, and how can we interpret all these technical legalities for these victims. Okay, the fun part, the pictures and the slides. The International Criminal Court has, the division in Uganda has a presiding judge, and that's our presiding judge. He's the head. He's called Justice Muchibi. That's the deputy. That's the third judge, Justice Nahamya. And we have a fourth judge as well, called Justice Owinidolo, and that's me, the registrar. That's the structure of our court. It is a basic domestic court. We have the judges, the registrar, and under the judges we have the legal assistants and the staff. Nothing unique, really a basic domestic court. But for us here today to understand why this division was created, why did the government of Uganda bother setting up International Crimes Division, I thought it would be pertinent for me to give you a background, timeline. How did this start? Who is the LRA and what did they do? What did the government do and what did the international community do in response? In 1987, there was war, and as you might know, Uganda's government, the President Museveni, came to power through fighting. He was also fighting against an existing government, and he won. However, when he came to power, the northern Uganda factions of other parties also wanted to share in that power, and they fought against him. There was the Holy Spirit movement by Alice Lakwena, who started to fight against the government. But when she saw she was weakening, she moved to Kenya, and Joseph Kony took over. When Joseph Kony took over, he tried to get people in northern Uganda to turn against the government. When that didn't work, Joseph Kony turned on the civilians themselves. Oh, so you won't support me? Then I'm going to kill you. And that's how the war started. And everything started to go wrong in the north. The LRA began torturing people, and Joseph Kony started a trend of self-preservation. What he would do is he would abduct children, train them to become soldiers, and then they would fight for him. UN statistics show that about 25,000 children have been abducted by Joseph Kony. Other statistics show that 60,000 children have been abducted. So that's what they would do. They would kill children. They would create child soldiers. And he had a very bad habit of torturing by cutting off lips, noses, and ears. I don't know why, but that was a trademark. And I remember one day I was using public transport. I was going to the office, and a lady came and sat next to me, and I turned towards her, and she had no lips, and I was just so shocked. I mean, there was just a gaping hole where skin would have been, and her teeth were just gaping out. And that's when I realized how much harm Joseph Kony had done. He would burn people alive, even children. And that's how he got fear. He would instill fear in people so that people would start to support his army. So in 1996, the government just couldn't handle it. They decided to set up IDP camps, internally displaced people, to bring them into one camp in order to protect them. However, even those camps were not free of the soldiers. They would still get into the camp somehow and kill people. So the children would walk every night 20 miles to town, to the city center, and just put their blankets down on the ground and just sleep there because they knew town was safer than the camps. So that's a picture of the kids sleeping in the city center. The government realized, okay, the camps are not working, let's introduce amnesty. So that was introduced, and it actually did a good job of returning all these people who had been abducted. Amnesty, under the Amnesty Act, if you surrendered and just said, I'm sorry for what I did, I was just forced to do this, can I come back home, you were let back. And some people really stopped fighting and they were able to come back and settle, but Joseph Kony and his cronies still refused to stop fighting. So in 2002, Uganda ratified the ICC Rome Statute. That's a very famous man, Ocampo, Mr. Ocampo, and that was in 2005 when he issued the ICC arrest warrants against Joseph Kony, Vincent Oti, Okoto Diambo, and the famous man now, Dominic Ongwen. However, even in 2005, when those arrest warrants were issued, nothing happened. Peace talks started in Juba. When the arrest warrants were issued, they got representatives from the LRA contacting the Ugandan government saying, we want to talk. So they thought of a neutral ground, and that was South Sudan. So the LRA met with the Ugandan government in Juba. And the agreement that happened in Juba is called the Juba Peace Agreement. And it introduced 3 mechanisms. Number 1 was to set up the court. So now we're getting the background of the International Criminal Division of Uganda. A formal mechanism comprising a fully fledged court of law to try the major perpetrators. That was agreed between the LRA and the government of Uganda. An informal mechanism comprising local traditional methods of dispute resolution and a truth-telling and reconciliation mechanism. Did you hear of the Gacaca courts in Rwanda? So we wanted to introduce a similar thing in Uganda and see how the traditional courts can also try perpetrators. We were so happy in 2006. We thought Joseph Kony was serious, but nothing happened. 2007, we signed an accord on reconciliation, and Clause 7 of that accord clearly provided for a special division of the High Court of Uganda established to try individuals who are alleged to have committed serious crimes during the conflict. So now it was all clear. Yes, there's going to be an International Crimes Division, and yes, we're going to try these perpetrators. So the US forces are now looking for Joseph Kony. Everyone is getting excited. Where is he? Where is he? We can now try him. Nothing's happening. In the meantime, under the Constitution, the Chief Justice set up the International Crimes Division. Initially, it was called the War Crimes Division, and eventually we were given more jurisdiction to try not only war crimes, but also international crimes like terrorism and human trafficking. We started the truth-telling and reconciliation. As I mentioned, when the Amnesty Act was introduced, the rebels, some people started to come back. So since we were not trying the perpetrators, what was happening was truth-telling and reconciliation. So those pictures, they're not very clear. They show an old lady really listening to someone who's testifying before the Truth-Telling Commission. In 2011, there was a legal notice again, like I mentioned, increasing the jurisdiction of our division. We could try genocide, crimes against humanity, war crimes, terrorism, human trafficking, and piracy. And then, wow, in June 2011, guess what happened? We arrested a man called Thomas Koyelo. Thomas Koyelo was one of the perpetrators. He wasn't under the ICC arrest warrant, so automatically what happened was he was brought before our courts. He was charged with 53 alternative counts under the Penal Code and 12 grave breaches of the 4th Geneva Convention. And all his violations, the offenses ranged from murder, kidnapping, aggravated robbery, and And he committed these crimes between 1996 and 2009. However, when he was brought before our court, he filed a constitutional petition raising the issue of amnesty. Remember, the Amnesty Act is still in place. So when his lawyers raised the constitutional question that if the Amnesty Act is in place, then why isn't Kwoyelo being granted amnesty just like all the other soldiers? And the annoying thing about the Amnesty Act was that it was just a blanket amnesty. It did not differentiate between what type of rebels could actually apply for amnesty. So this constitutional petition has been going on until finally, recently, it was brought before the Supreme Court, and we are awaiting judgment. I'm praying and hoping that the Supreme Court will say, no, you don't qualify for amnesty because you did not surrender, you were captured, you didn't want to stop, we had to force you to stop. I mean, you'd think this was straightforward, right? But no, the defense counsel is doing everything and anything to say, no, he wanted to surrender, but he was captured before he surrendered. I don't know how that makes sense, but, so he should be granted amnesty. So the Supreme Court is really trying very hard to see, read between the lines, but I'm hoping that the Supreme Court does not deliver the judgment until the Amnesty Act expires in May this year. So once it does, then they will have no other way but to bring him back before the court, because the Amnesty Act would not exist. Possible? Not possible? I wonder what the defense counsel would think. Can you still stand on a defense if that act does not exist anymore? I don't know. So that is the one big case that did come to the ICD, the International Crimes Division, but was unfortunately delayed. That is the ICD court, and those are the staff. We have so far managed to put together the rules of procedure and evidence for an International Crimes Division, so we can actually now start to operate. We have the regulations in place, so we're ready to go. Today, what's happening? Dominic Ongwen was captured by Seleka rebels, and he's been brought here, right? Last night, Christoph, that's what he said? Great. And, there are all these questions right now. Why has he been brought to the ICC? Why isn't the ICD trying him? And maybe there's no confidence in the ICD, and it would be interesting to have, someone maybe from the Ministry of Justice come and explain that, because I think it was mainly a political move. But from my point of view, I think there are three questions we need to look at when we're looking at the Dominic Ongwen situation. One, the crime spread not only from Uganda but into 4 different countries. So you're looking at Uganda, Congo, South Sudan, and the Central African Republic. Number 2, the ICC arrest warrants were issued before the ICD came into existence. And number 3, we still have an Amnesty Act in place. So I would love to hear your views about, considering those 3 factors, can the ICD still proceed? And that is Joseph Kony, who is still at large. We are hoping and praying that this surrender or capture of Dominic Ongwen has severely weakened the LRA, and Joseph Kony will soon surrender. That will be left to be seen. But he's still at large, he's still operating somewhere in the Central African Republic. So that was the quick timeline of the ICD. I just wanted to quickly give you a background of what really happened and why the ICD was put into place. Okay, so the Juba Peace Agreement, then we got the legal notice, and then the practice direction, and then the International Crimes Division was put in place. I just want to play a short documentary from the Invisible Children. Have you watched Kony 212? The video that went viral in 2012? And the founder kind of went crazy after that. I think it was too emotional, you know. Being with these kids, listening to them, their stories are really heartbreaking, but I think it's worth watching. I just made a 5-minute clip. I'm not going to show the whole documentary. I wonder if we could dim the lights and just watch a bit of this.
And just like his dad, he likes being in movies.
Action!
And making movies.
Daddy, watch this.
But he was born into a pretty complicated world. And as a dad, I want him to grow up in a better world than I did. And because of the course of events in my life, I see a way to get there. It has become my job. Who are you to end a war? I'm here to tell you, who are you not to? Hey Gavin, what's up? Years before Gavin was born, the course of my life was changed entirely by another boy.
And who's this right here?
Jacob.
Who's Jacob?
Jacob is our friend in Africa.
It's been almost 10 years since Jacob and I became friends. It's okay, they're nice. They're different than sharks. But when my friends and I first met him in Uganda, in Central Africa, it was in very different circumstances. He was running for his life. You go to school here?
Yes,
Yes, that's how you know English so well.
I know.
Yeah. How many nights have you stayed here? The night I first met Jacob, he told me what he and other children in northern Uganda were living through.
We worry the rebels, when they raise us again, then they will kill us. My brother tried to escape. Then they kill using power. They cut his neck.
Did you see it?
I saw.
We fear that if we sleep at our home, we can be abducted by the rebels. Because our home is far away from town.
They will catch us, then they take us there in the bush. So come here to save our life.
This is absurd. This has been going on for years. If that happened one night in America, it'd be on the cover of Newsweek. What is it that you want to be when you grow up?
For me, I wanted to be lawyer, but no money. I don't have money to pay my school fees, so that I learned and then I be lawyer.
After spending a few weeks with Jacob, he told me something I would never forget.
So it is better when you kill us. And if possible, you can kill us, you kill us. For us, we don't want now to stay. Because
You don't want to stay on Earth.
we are only two, no one taking care of us. We are not going to school. So
You would
how are
rather die than stay on Earth.
Yes. How,
Even now.
even now. Are we going to stay in our future?
He told me more about his brother and what he would say to him if he were still alive.
I love you, but now I miss you. So it is better when we meet. We are going, even if we are not going to meet, but we may meet in heaven. You see? So it is better. I will not talk much. I will start something. Because if I saw my brother once again, I don't.
Okay, so it was just a 5-minute clip. If you want to watch the whole documentary, we could find it on YouTube. But that's just the story of one victim. There are thousands and thousands of victims, and my concern with having a trial in The Hague is how are you going to get all these victims to the courts? How are these victims going to see the reality, the justice that is so much waited for? But now you're saying what, you can only call 41 witnesses for the case of Dominic Ongwen, when you had thousands and thousands of children like these who could come and testify, tell us their stories. I mean, this is only an account of one boy, but for the accounts of the girls, it's just such a sad, sad story. I don't know if any of you have read about the Aboke girls who were abducted, the 139 girls who were abducted. I mean, if you listen to what these girls went through, you would wonder what kind of animals these people were. So that was, I want to go back to my presentation. I don't know how to do it here. The current situation now is that the US forces are still looking for Joseph Kony, and they're still deployed in the Central African Republic. The International Crimes Division now has increased jurisdiction. We can try war crimes, and on top of that, we have increased power to try terrorism and human trafficking. However, we don't have a specific law on witness protection. The increased jurisdiction, like I already said, includes genocide, crimes against humanity, war crimes, terrorism, human trafficking, and piracy. Those are the cases we're dealing with right now. The first one is Koyelo, that's before the Constitutional Court, but we have others on terrorism and human trafficking as well. We have a witness protection bill that has been put before Parliament, and we're hoping that sometime this year it will be passed into law so that witness protection actually becomes law. So just a slight recap on what I've talked about today. The main issue and the main challenge I see for the ICD is the Amnesty Act. Once that one is out of the way, I don't see why the International Crimes Division cannot try cases like Dominic Ongwen's. We are yet to have a law on witness protection. It is still a bill. The court structure is that of a domestic court, obviously. You're not going to get a domestic court anywhere that is structured like the ICC or a criminal tribunal. That is built with time. And resources are limited. That is, of course, because it's a domestic court. But the achievements are there as well, and we have rules of procedure in place. So if you're saying that you're bringing a case to court, we can try him. We do have the rules, we do have the regulations. The judges are there, the lawyers are there, the registrar, myself, I'm there. So in conclusion, the ICD is hopeful that the Supreme Court would see it fit to return the Thomas Koyelo case, and that would be our first case. And what's so interesting about these cases are that they're all interlinked. Dominic Ongwen fought side by side with Thomas Koyelo. So the witnesses who would appear before my court in the Thomas Koyelo case could also be the same witnesses who appear at the ICC for the Dominic Ongwen's case. But I see an overlap, a kind of overlap happening. I mean, if I proceed with my Koyelo case and the Dominic Ongwen case is going on as well, how are we going to bring that evidence together if we don't have some kind of collaboration on complementarity right now? So, why is the ICD doing all of this? Why are we here? Why are we talking about international criminal justice? Why are we bothering with complementarity? And I think the reason is simple. It's the same reason why the ICTY was set up. The ICTR for Rwanda was set up. Everyone said in the beginning, oh, the International Criminal Tribunal for the former Yugoslavia, it can't work. That was in the 90s. But look at how much they accomplished. 160 people charged and thousands of witnesses came to testify. Look at the ICTR. Look how that worked. Over 90 people charged, hundreds of witnesses testify. The ECCC in Cambodia, the Special Court for Sierra Leone. All of these people said it wouldn't work, but they did. And they did try, and they did get their convictions. So we're doing this for that 9-year-old girl who was abducted, raped by rebel soldiers. We're doing this for that 10-year-old boy who was forced to become a soldier. He cut his mom and dad to pieces just to show the rest of the world that, yes, Joseph Kony has power. We're doing this for the mothers and fathers who will never see their children again. And we're doing this for those men and women who were abused, raped, noses, lips, ears cut off for no reason. And finally, we're doing this to make a stand against impunity and to let the rest of the world know that Uganda will and can try perpetrators of war crimes. Thank you. I cannot make a presentation without referring to one of the greatest men who ever lived, Nelson Mandela, who said, "It always seems impossible until it's done." Thanks.
Thanks a lot for that very interesting and comprehensive presentation. There's now some time for Q&A, so to whom can I give the floor? We have a mic. My colleague Alina has one. So who would like to ask a question? Can you please also state your name and affiliation, please?
Hi, my name is Maria from the Women's Initiatives for Gender Justice. I just have a short question about when you mentioned that you were hoping that the judgment of the ICD, of the Supreme Court, actually would fall after the Amnesty Act expired. I was wondering about the relevance of this because how I had understood it, and I might be incorrect, is that what the time that would be relevant would be when Poyelo had surrendered or when he was captured. Why is it relevant when it expires relative to the judgment? Thank you.
Somebody else will take a few questions. Yes.
Hi, just had a question with respect to the Amnesty Act. You mentioned that it's due to expire. Are there any moves by the government to extend its existence, and if so, for how long? Thanks.
Sorry, is that okay?
No.
I'm Isabel. I'm from the ICTY. I just had a quick question about whether there's been, you sort of spoke about how you'll need more collaboration with the ICC, and I was just wondering what there's been so far, particularly with Onward.
Okay, maybe one final and then we'll do the second round after this, don't worry.
Yeah, my question is a bit related, so I was wondering what the reputation is of the ICC in Uganda, like among the common folks, because in Africa, there's a lot of, how do you say that, concern about what the ICC is doing and whether it is contributing to anything at all. And I was also wondering if you could say something about this new regional court being set up. So this Court of the African Union will now also have criminal jurisdiction and in a way will compete with the ICC. Does that also apply in some way to Uganda? I'm not sure.
Thanks very much for the questions. I'll start with Maria. The relevance of the Amnesty Act and why it's relevant that it expires. When the Amnesty Act was put in place, it was supposed to last for only 2 years. And anyone who applied for amnesty after that was not supposed to be granted. You're given 2 years to think about it. Honestly, if you haven't surrendered in those 2 years, then you do not qualify for amnesty. However, the Parliament of Uganda kept on renewing it every 2 years. And the reason for this was because, and I'm going to answer your question together with his. The second speaker, you didn't give me your name. Are there any moves by the government to extend its existence, and why? There was a great divide between the parents of the children who had been abducted and the victims. The parents wanted the children home. And they really built a strong case for their children. So the parliament was kind of torn between, stopping the war, getting the children back, and then. So you find that these people kept on pushing for the amnesty to be extended. And it was extended successfully every 2 years. So between the extensions, people were not eligible for amnesty. It gets a bit complicated. So that's why I'm saying that actually when Coelho applied for amnesty, that was in 2010, and between 2010 and 2011 when the Amnesty Act was supposed to have expired, actually. So that's why I'm saying that there is a possibility that if it expires in May, he would be considered as having applied when it had expired then. I mean, it would be more obvious for the public and for the court to apply that. But if it is still in existence, then he could very well say that no, under the existing act, I can be afforded amnesty. So that's why I was saying that the expiry would actually affect the judgment of the Supreme Court. The next question about collaboration with the ICC, was there any collaboration? The ICC has been seen as very distant to Uganda. The ICC does have an office, but it was really created for victim reparation and not really for court work. So the victims in the north have been receiving some kind of funding through two organizations. I think there's an association for torture victims, and I don't know which other one. But it is really seen as far removed from the African-Ugandan situation. And I think, in a way, now going to the next question of the African Union, looking at the statistics of the cases being tried in the ICC, there is a case for Africa, and you can see that most of the cases are from Africa. And so, really, the reputation of the ICC in Uganda and concerning Africa, yes, we're all saying, yes, the ICC is great. They're trying all these bad guys, but why is it always Africa? You can't really justify Syria, North Korea, all these people are there, So, and now the African Union has set up a criminal division. It has been set up. I don't think they have their first case yet, but yeah, it is in existence. I don't know how it's going to work, but yeah, it is there, so confirmed, yeah. Thank you very much.
Second round of questions, maybe Janet first.
Hello, Janet Anderson from RNW. I wanted to ask you a question about the ICD's jurisdiction. I saw that you put piracy down as one of the crimes. I'm sure that can happen in all kinds of situations, but you don't have a sea border. So I was wondering about that. And I have a quote here from Henry Oriem, Uganda's State Minister for International Relations, where he says that because Ongwen's crimes went beyond the borders of Uganda, it fell out of the jurisdiction of our courts of law. So I'd like your comment on that.
Hello, my name is Tom. About the sea border, there's a lake there, though, down in the corner. So, I'm from the Great Lakes region of the United States, and there was a lot of pirates on the lakes. Just because it's not an ocean doesn't mean you can't be a pirate. I have a question. What is your feeling on Article 46, I believe it's A, bis A, dealing with the new African Court of Justice and Human Rights, the one where they allow, where they will not prosecute a senior government official until their time is up at office. Thank you.
Hi, my name is Ella from IWPR, and I wanted to ask, if Coelho is tried, what sort of sentence will you seek?
My name is Rachel. I'm from the Legal Research Masters in Utrecht. I was wondering, this is a blanket amnesty that was formed in the Amnesty Act, and I was wondering if you could sort of reform this Amnesty Act, if we would go back to 2000, would you put in place a conditional Amnesty Act, or maybe a bigger role for the TRCs, or how would you change that?
So one question in the end, and let's stop and go for the third one. Yes, please.
Okay, I'm Lydia. I'm from Kenya, and Kenya too is in the process of setting up an international crimes division. So my question is, you were talking about the divide between the national prosecutions by the ICD and the prosecutions at the ICC. So I was of the opinion that because the ICC usually goes for the most responsible, then because the ICD draws from the example of the Gashasha courts, then the ICD should go for the other perpetrators that are not targeted by the ICC. So what do you think about that? Yeah.
Thank you. Many good questions.
Yeah. Wow. Okay, let's see. The first question by Janet about the ICD's jurisdiction. Actually, when Uganda domesticized the Rome Statute, an ICC Act was now made Ugandan law. We are now an international crimes court, and we do have jurisdiction in even other countries. So that one, once you domesticate the ICC statute, you become an international crimes court with jurisdiction, as long as you they are one of the crimes listed under the Rome Statute. So yes, we do have jurisdiction even across our borders. And yes, we do have a lake, a big lake, and we've had so many problems with, I think, Kenya, and I don't know, claiming one of our islands and attacking our islands for some kind of, I don't know, marine fishing something. But yes, I think we're about to lay charges of piracy against Kenya. But thanks, Tom, for that. Article 46, why will my views on the Africa saying that we will not prosecute senior government officials till they're out of office. I think it is more of a practical article. We saw how it went with the Kenyan case, and yes, senior government officials should be held responsible. But remember what I said in the beginning of my presentation, what's the reality? What's the practicality of some of these provisions? Do they really bring justice? Or, like we said, they just make other people vulnerable, and you end up with dead witnesses in Western Kenya, like what happened, because these are people with a lot of power. People who are still in office, they've got constituencies, they've got followers. It just wouldn't be safe for someone to get involved in such a case. So the practicalities, yes. The article is a good one, yes, we should, but what are the practicalities? I think it's just not a good idea. That's my view. I don't know what the other people think. The next question about if Coelho is tried, what kind of sentence would he get? It's very interesting you mentioned that, because the death penalty is still existent in Uganda. But we are now moving away from it, and the death penalty is only given in the rarest of cases now. So I can confidently say that if Coelho was tried, the maximum sentence he would get was life. I do not think he would get death. Uganda as a country is moving away from that. Rachel, about the condition, oh yes, my views on amnesty is that it should really be conditional, it shouldn't be blanket. I think there are a lot of precedents on that, so many cases on that. It should depend on the level of participation, the frequency of participation, how much power you wielded, coercion, duress, age, all these things should matter. And I don't think someone should just be given amnesty just because he says he's sorry. What was his participation, and what really happened? Lydia from Kenya. my sister. Yes, the Kenya is also looking at setting up an ICD, and I think, yes, what you said is right. Really, the most serious crimes should come to the ICC, not because we cannot try them, but because the ICC has more experience. Let's accept that, you know. And I think it would give us good practice to start with the lesser, you know, the ones who are easier to prosecute, and then build up on that. But that's not saying that we cannot try them. But practically speaking, yes, I think the ICC is more equipped, and therefore they should be given the worst perpetrators. Thank you.
Was at least one question at the back? Yes. Two. Another one from Tom.
Thank you. Can I say firstly, it's Matthew Gillette on behalf of Peace and Justice Initiative, and thank you a lot for providing this frank and detailed description of the situation in Uganda. I was interested in the practical matters at the ICD. Let's say a group of 30 or 40 of the LRA-type perpetrators or alleged perpetrators were picked up, and we'll put aside the Kwielo whole question. Would you have the capacity to run trials for that many accused, or would you have to sort of significantly change the structure of the division? And secondly, let's say the Kwielo case gets sent back and gets up and going. Approximately how long do you think it would take to run there? Because I'd be interested in the comparison with ICC cases, which obviously are quite slow compared to most domestic cases. So thank you.
Thank you for your presentation. My name is Jan. I have a question concerning the rules of procedure and evidence. You are a division of the judicial system, the Ugandan judicial system. I'm wondering why you need to adopt a new code of procedure and evidence. Why aren't you applying the criminal code of Uganda? And what is the difference between the criminal proceedings, normal criminal proceedings applied by Ugandan courts and this division? And does this question arise? A question of legality and the retroactivity of these rules of procedure and evidence, because it is adapted after the crime were committed. Thank you.
Hello, me again. Do you believe that the government of Uganda will actually try underneath the rules of procedure and evidence underneath their own statute to try to bring portions of the trial or even the confirmation hearing of Dominic Ongwen down to Uganda, just so, as you mentioned before, the victims would, you think it would be good if the victims could actually see, and you think the government might actually try to do that? I mean, especially with President Museveni's outspoken, the way he's been outspoken in the past few years against the ICC, and work in collaboration maybe so that victims can come and see during part of that. And of course, it would have to go through the judges. But what are your takes on that?
Many questions tonight. Very good.
Thank you. My name is Andrea, University of Milan. Please, just a very simple question. What are the working languages of the ICD? I'm interested in terms of relationship between international and the national, and I'm curious which are the languages in which the judgments in future will be written. Thank you.
Let's conclude this round, because I see there are even more. We'll go to the fourth round after responses.
Matthew, the first question about whether if there were like 30 perpetrators, what would the capacity, does the ICD have the capacity to try such a case? Wow, this would be like really huge for the ICD, and I must admit this would be like the first for it, and I don't know. Right at this moment we have an international case actually involving 3 countries. I don't know if you heard of the twin bombing in 2011, where the Al-Shabaab bombed 2 places in Uganda and 76 people were killed. So that has been our first international case, and it involves Somalia, Kenya, and Uganda. We have really woken up as to what kind of capacity our courts have, and right now I think in a criminal case the burden is on the prosecution. The chambers, the judges are always ready, the registrar would be ready, but I've really seen the prosecution side really having to pull their socks up in terms of investigations, witness protection, all these things. So this would be a challenge to the prosecution, but as for the court, the judges, the chambers, no, I don't think so. And the structure of the court, yes, it would have to change. We would need to really put a very good investigations unit in place, for witness protection, security in place. I do not see in our current situation protection of documents, for example. We do not classify documents the way they're done here. You have vaults and strictly confidential and classified and unclassified, and it's really well laid out. Those are things we seriously need to think about. How long would the Coelho case take? It's all down to the prosecution, really. And I think, generally speaking, criminal cases don't take very long in Uganda, but looking at the number of witnesses, again, that would depend on how many witnesses the prosecution would like to call, and usually the defense counsel tries to match that, don't they? Okay, if they could bring 100, I'll bring 200. So it all comes down to the prosecution, so we'll just have to wait and see on that one. But yeah, criminal cases, generally, they go very fast, but again, capacity, witnesses, it depends on the number of witnesses. Jan, rules of procedure. Why would we need rules of procedure when we have the criminal code? That's a very interesting question, and that's what I thought when I first came to the International Crimes Division. We have our criminal procedures. I mean, why don't we use that? But then, these are different types of crimes. You're not looking at 2 murders, you're not looking at 6 murders, you're looking at mass killings. How would you then explain the principle of habeas corpus, for example? Where's the body? If you're going to prove a murder. Okay? So this, when you start to think about it, the normal principles in criminal law, you can't produce the body. These were crimes committed 10 and 20 years ago. The most they can show you is a grave, and you can't even really, so there's so many aspects to international crimes cases, and like you've already seen in the Ugandan case, you're going to Congo, you're going to South Sudan, you're going to Central African Republic. The rules of procedure takes all that into consideration and creates a formal structure where you can apply these laws over a wide range of crimes, and that's what I've come to appreciate. It gives the law the practicality of actually trying a case within certain processes, which makes it easier. So that is the reason why rules of procedure have to be put in place. And the issue of legality and retrospectivity, these are now new laws. At the time the crimes were committed, the laws were not in place. I think the ICTY has a very good decision on that. And that is the case, which case was that? I don't know if it was in Mladic or, where the court actually ruled that it doesn't matter. This is now a recognized national crime, so you committed and you will be held responsible for it. So I think that is a great, I will get you the case and the judgment for it. So we are relying on that as well. That's the new precedent in international criminal justice, retrospectivity, big cross. Tom, do you think Dominic Ongwen's should, oh yes, That would be very interesting, and I think the witnesses and victims are really waiting for us to set up part of that trial in Gulu, in northern Uganda. And I think it would be more meaningful because there's no way thousands of victims would be able to travel to The Hague. But again, like I said, the practicality of, the ICC having more experience. This guy is under the ICC arrest warrant. This would be the first time ever that the ICC removes itself from The Hague and actually comes and sits in Gulu, in Africa, which would be really interesting. And the ICC has money to do that, so why don't they do that? Why do you always need to stay in The Hague and, put these victims, these accused people in comfortable hotels and, they're by the beach and they go to the best hospitals and all these things? Yeah, it would be great if they could be brought to Gulu. Gulu is where, it's the center of northern Uganda where these atrocities were committed, and it would be great. But again, the three reasons I raised in the beginning might really make people decide that Dominic Ongwen should remain here for the moment. The existence of the Amnesty Act, the fact that these crimes were committed in 4 different countries and each country would want to have their stake in it, and all the rest. So there you go. Andrea, what is the working language of the ICD? It's interesting. An international criminal court should actually have like English, French, but in our at least if I look at this case of Coelho, the working language is Luo, Acholi, and English. And I think, it's because, these are the languages that the accused speak, the victims speak, and the witnesses speak. Very few of them even have gone to school or even understand English. Dominic Ongwen speaks very little English himself. So those are the working languages. But it's interesting that you've actually raised that. And I think if we were saying that we want to try international crimes, I think we need to consider the working languages of an international crimes court, and that would be English, Portuguese, French. Is it? Or English and French? To begin with? Yeah, I'm asking you now.
Well, now the ICC, they work in 2 languages essentially, English and French. For the ICTY, English came to be the predominant language, which facilitated a lot the diffusion of the judgments. Recently, I was teaching in Turin, and my students say, "Oh, but there is a judgment of the ICC which is written in French, and we cannot read it because it's not our language." So I was thinking in terms of looking the future to your case law, say, well, I hope it will be in English.
Yeah.
That would be already...
Definitely. Our working language in Uganda is English, Commonwealth country, so yeah.
French, I don't know. I'm not asking that. But English
yet.
would be great.
But French will get there.
And otherwise, we will make an English translation and put it on our ICD. Okay?
Exactly. So I think those are the questions.
One or 2 questions here on the right.
Okay.
My name is Bella. I'm deputy prosecutor in Cameroon, and here I work for ICTY. I really hope that French will be part of the languages because my first language is French. Now I have a comment and a question. The comment is that I really think that Uganda was fooled in the Juba's agreement because when the Ugandan government decided to negotiate with Kony, he was already under a warrant of arrest of ICC, but Uganda accepted to negotiate. And then Uganda did his part of the job, putting in place the ICD, and now Kony is at large. So what was the part of Kony in that Juba's agreement? What was his part? And what were the means you were thinking to put in place in case Joseph Kony didn't do his part of the job? Because now you are running after him, and when we see that it was an agreement at the beginning, it's just weird. So, don't you think that the Ugandan government was a bit fooled?
Hello, my name's Ruby. I just wanted to know what your opinion was on if international criminal law should or can or have any role in this idea of complex victimhoods where child soldiers then go on to perpetrate the same crimes to which they were victims of themselves. And if you think international criminal law can say anything about that.
Yeah. Just one more.
It is also the last one, if there are no other.
Hello, my name is Gabriela Hija-Augustinova. I'm a PhD candidate at the International University of Vienna. I have a question. You mentioned that as part of the Juba peace agreement, Gajacha-style mechanism was actually planned. This never materialized. Now, in light of limited capacity of the ICD and the blanket amnesty law, is there any kind of discussion to actually still introduce this kind of mechanism? And you personally, would you see value in this? Thank you.
We're done, I guess. Yes, Bella, you're right in a sense to say that the Ugandan government was fooled into entering negotiations, which we thought, both parties would keep. You sign an agreement and you hope for the best, And the LRA, the representatives, really showed the government that they were willing to cooperate. You won't believe till September, October, when I was still in Uganda, Joseph Kony was still saying he wanted to lay down his arms. So this is a game he has been playing since they signed the agreement. It's been like a cat and mouse game. And for anyone who's done negotiations internationally, it's not a one-day thing. It can really be long and drawn out, and you have to keep on talking and bringing him out, and it's a lot of back and forth, and ambassadors and everybody, and it's just so drawn out. And you always, leave a door open, hoping, for Joseph Kony one day to, wake up and, but he's been playing this game till today. He keeps on saying, I want to surrender, but I want A, B, C, D, and you go back to him and say, okay, we'll do A, B, but we want to C, D. So, yeah, you can say we were fooled in a way, but in negotiations, you just cannot afford to shut the door. You've got to keep on talking. So, that's the reality. Really, if international criminal law considers child perpetrators as victims, that's a very tough one. I would love to say it does, that, okay, these were child soldiers, they were abducted at 10, 8, 12 years, they were forced to do whatever they did, so they should be forgiven. But the reality of the fact is that even after they attained the age of 18, 21, they continued, they chose to stay. Some of their colleagues ran away, but some of them continued and even rose to ranks like deputy, commander like Dominic Ongwen. So how do you explain that? There's got to be a difference. Just like how we're saying you can't grant a blanket amnesty. When you look at these cases individually, you have to look at the individual. Dominic Ongwen was the head of one of the fiercest brigades. The army had different factions, and his was the most feared. They would cook people alive in pots. There was a story that his team or his brigade went to a school one day and asked the children, "Are you hungry? When was the last time you ate beef?" So the children were so happy. And they said, oh, we had not eaten beef for a long time. So one of the soldiers asked, where's your head teacher? Oh, he's there. So the man stands out and he was practically slaughtered in front of the kids and cooked. So how do you explain such, and you call him a victim? You know, so again, I bounce the question back to you. Other question about traditional courts. Yes, there is a very serious discussion about it, and we think that it can bring a lot of healing to the people in Uganda, because the international criminal justice system just seems so far away, and there's so many other smaller cases that can be handled by the traditional justice system. And I think this is going to take place as soon as we actually get the perpetrators. Like I already explained, we only have the one case, Coelho, but there's so many other cases as well. And I think in between one of these cases, we will have to go down the line of traditional courts. We have a custom in northern Uganda where they say that if someone has been killed in a family, you pay with blood. And the blood they mean is by heads of cattle. So, for instance, if you admit that I killed the son of this family, then I pay back the blood with like 20 heads of cattle. But how economically viable is that? Thousands of people, how many is that? Millions of cattle? So we're still talking to the traditional leaders. We're still trying to figure out a way of actually applying this traditional justice system, but it is a system that is easily understood by the people, and it would be easier to accept. So we are not shutting that out. We are really eager to take that up. Thank you.
Thanks a lot for the many good questions and answers. I've written a couple of questions for myself just in case, but as you can see, it was not really necessary. I would like to thank everybody, of course, for coming to the Ulster Institute, in particular, Mrs. Ssali Lule. We have new supranational criminal lectures coming up. On the 3rd of March, we'll have Kevin John Heller, who is Professor of Criminal Law at the School of Oriental and African Studies at the University of London. He's also, of course, well known from the blog Opinion Juris. He will speak about defining international crimes. And on the 29th of April, outgoing Judge Ekaterina Trendevilova will reflect on her 8 years on the bench at the ICC. And others will follow, so please check the new website of the Ulster Institute, or better sign up for our mailing list on IHL and ICL. And in addition, don't forget to like us on Facebook. It's facebook.com/SCL Lectures Series. And finally, I would like to let you know that increasingly the videos of these kind of lectures are being posted online on that other ICD, the International Crimes Database, available at the internationalcrimesdatabase.org. So please have a look there as well. So thanks again for coming, and enjoy your evening.